United States, and I'm also pleased to say a distinguished professor of law and government at Regent University, also a senior fellow, a distinguished fellow at our Law and Justice Institute at the American Center for Law and Justice, John Ashcroft. General.
I can't imagine anything that would be more pleasing to the founding fathers of the United States of America than the kind of robust, transparent argument and discussion about these issues. I think that's what the United States of America is all about. And we all have as our role models those who have gone before us. Governor mentioned Justice Jackson of the United States Supreme Court and quoted eloquently what he said about liberty and freedom. But Justice Jackson was also a part of the Quirin Court when the German saboteurs came in Florida and in New York. They came in on the 15th of June and they were executed before the 15th of August with the approval of the United States Supreme Court by military commissions. And two of them claimed citizenship in the United States, and the court said, well, that just doesn't make a difference. So Justice Jackson, while he understood liberty, he also understood the necessity to defend it. Nothing like that has happened in recent times, let me say that. I'm not sure I'm very proud of the way the things happened in the Quirin case. But let me assure you that that's not the kind of activity that's been undertaken in recent days, and because it need not be, and we ought to be careful, very careful about what we do in the defense of this country. And we ought to recognize that the courts of the United States do oversee us and that they have the final word. And I don't think there are any things in the Patriot Act that aren't supervisable by the judicial branch of the United States. The suggestion that things can happen and there is no opportunity for supervision or oversight by the courts, I think is one that I would have difficulty with. If you want to resist an administrative subpoena, and there are about 300 instances where in the United States where for all kinds of things, whether it's nursing home fraud or healthcare situation or something else, and an administrative subpoena is issued, you can just resist it and go to court and have it litigated in the United States. So this is a country where the rights of citizens are regarded. Now, I won't guarantee you that the courts will say what they've said in the past. When we were working to defend the United States, there are times when the Supreme Court has set aside what we did. It was interesting to me that 11 out of the 12 Court of Appeals justices that ruled on 4 court cases where the Supreme Court eventually set aside what the Justice Department and the administration has done, 11 out of the 12 Court of Appeals justices agreed with what the Justice Department had done. But it was only when you get to the Supreme Court where they have a significant commitment to the idea that law is to be grown and to be migrated and evolved, that they changed the law in one respect or another in order to accommodate something new. But we live with that because we are a society that believes in the rule of law. I think we need to ask that we believe in the rule of law, not just the rule of lawyers, though. So we need to ask that the courts be able to announce rules that are intelligible and consistent so that we know in the defense of freedom what we can do and what we can't do. Because there is nothing quite so paralyzing as indecision and uncertainty. So I want to thank you all for your involvement here. I want to thank each member of this panel for what they've